Welcome to Ask the Lawyer International Edition with attorney Brian Figueroa of the law firm Figueroa and Associates in New York. We hope you enjoy the show, which features immigration visitors visa, starting and doing business in New York, entertainment and business visas, religious visas, and much more. Whether you are outside the U.S. or have family in New York, the number to call, share, and keep is 855-768-8845. That's 855-768-8845. Please schedule a consultation with us at www.askthelawyer.us. That's www.askthelawyer.us. This is Ask the Lawyer International Edition. You have questions? We've got the answers.
Welcome to Ask the Lawyer, your premier Jamaican radio show dedicated to unraveling the complexities of the U.S. immigration system. Hosted by me, Ashley Dawkins, a proud Jamaican national, alongside esteemed New York-based immigration attorney Brian Figueroa, who brings over a quarter century of specialized experience. Together, we explore the benevolent aspects of America's immigration laws. Tune in to Ask the Lawyer for insightful guidance through the intricate world of immigration.
Good day, good day, good day. My name is Brian Figueroa of the law firm Figueroa and Associates. This is Ask the Lawyer. You got questions, we got answers. The number to call, the number to keep, the number to share is 855-768-8845. Again, 855-768-8845. Family-based immigration petitions. Whenever someone comes to the United States of America and they overstay their time here, within 6 months, if they overstay their time, they are subject to a 3-year bar if they leave the U.S. If they overstay by 1 year, it's a 10-year bar. What does that mean? Well, the only area of legalization for that person coming to the U.S. is either one, a political asylum application that must be done within 1 year of entry into the U.S., unless there are circumstances that may warrant a late filing. 2, marriage to a U.S. citizen or a green card holder. If it's marriage to a U.S. citizen, both the spouse, all children under 18 at the time of the marriage would qualify for that U.S. citizen spouse to petition for them. Those applications, if the family is in the U.S., are done quickly. If the person entered the U.S. without inspection, that U.S. citizen beneficiary will have to get what we call a provisional waiver to pick up their green card from their home country. If you have a brother or sister in the United States that is a U.S. citizen, people say, well, that petition takes about 12 years. Why file those petitions? That's not a good idea. Whether you want to come to the U.S. or not, your brother or sister petitioning for you that is in the United States and is a U.S. citizen, even though it takes a long time, it makes sense to put that petition in. So while you are in your home country, obviously waiting for that priority date to become current, obviously you live your life normally like how you do now, but in the future, when that priority date is current, your spouse, yourself, your children that are under 21 when the priority date is current would be able to migrate to the United States of America. So that brother-sister petition may not benefit you, the sibling, overseas, but it obviously could benefit your children later on that may want to attend college in the United States or work in the United States of America. Family-based petitions are obviously very important, and we should obviously plan accordingly. My name is Brian Figueroa of the law firm Figueroa and Associates. This is Ask the Lawyer. You got questions, we got answers. The number to call, the number to keep, the number to share is 855 855-768-8845. Again, 855-768-8845. If you have a family member in the United States of America, they could call us for a consultation, or you could call us from overseas for that consultation. You could schedule that consultation at our website, www.askthelawyer.us. Again, www.askthelawyer.us. If you would like to keep abreast of U.S. immigration law and other articles that give different areas of migrating to the United States of America, you could subscribe with your cell phone at our website, and you will get alerts on your cell phone with that newsletter. Thank you.
The United States is consistently ranked among the best internationally for its competitiveness. Are you planning to start a new business or branch of your business in New York? Attend our Chamber Coalition's 5-week webinar series, Small Business Sense Bootcamp. We provide education and business preparation for small business owners and startups. Learn the basics of business planning, how to finance your business credit, marketing, and social media strategies, small business solutions, legal, tax, accounting, banking, and insurance, and how to do business within New York City, New York State, and corporations. Register at startupsbootcamp.eventbrite.com.
Divorce, separation, support, custody. The common factor? They keep you up at night. Sleep well knowing that you have the law firm of Figaro and Associates on your side through this difficult time. Don't divorce your money. Don't divorce your children. Divorce your spouse. Whether it's a contested or uncontested divorce, the law firm of Figaro and Associates will guide you through every step of the process. From child custody to property and debt concerns, the law firm of Figaro and Associates has the experience and expertise in handling cases involving significant assets and complicated issues. A divorce can be one of the most unpleasant experiences a person ever has to go through. Don't do it alone. Stop the sleepless nights and call the law firm of Figaro and Associates, 855-768-8845. That's 855-768-8845, or visit 311divorce.com. That's 311divorce.com. At the law firm of Figaro and Associates, a divorce is not the end, it's a new beginning.
Hi, good day. My name is Ashaki Foster. I just want to send out a shout out to Mr. Figaro and his staff, thanking them for all that they've done for me so far with my social, my green card, and now I'm finally a citizen. And I just want to recommend him to the people in the U.S. and also the Caribbean. Thank you.
Our weekly immigration news roundup is brought to you by the law firm of Figaro and Associates. For a consultation on any immigration or legal matter, please call 855-768-8845. That's 855-768-8845. For full stories and more immigration news, visit www.theimmigrantsjournal.com. That's www.theimmigrantsjournal.com.
Hello, my name is Mary Campbell, legal assistant at the law firm of Figaro and Associates, and your presenter with this week's immigration news. We begin with Kamala Harris has an opportunity to reframe the immigration conversation as the Democratic nominee for president. As the country continues to dissect the ramifications from President Joe Biden's decision to drop out of the presidential race, the attention has quickly shifted toward Vice President Kamala Harris. While she has not been confirmed as the nominee for the Democratic ticket, she has obtained commitments from most of the required delegates, received key endorsements from party leaders, and has not had a rival publicly contest the nomination. It seems likely that Harris will be the new Democratic nominee for president. This change in nominee has reinvigorated the Democratic base. Harris received $81 million in donations in the 24-hour period after the announcement, the highest single-day total for any presidential candidate. This newfound energy also opens an opportunity for the Democratic nominee to change the narrative around immigration. State Department streamlines temporary visas for college-educated non-citizen workers, but questions remain about its impacts. Some immigrants who have graduated from college in the United States and have a pending job offer will have an easier time receiving a temporary employment-based visa, thanks to recent changes from the Biden administration. This will include deferred action for childhood arrivals, DACA, beneficiaries, and other college-educated non-citizens. The Department of State, DOS, updated its guidance on July 15 to consular officers for recommending waivers related to temporary or non-immigrant visas. About a month ago, the Biden administration announced 2 initiatives to streamline bureaucratic processes, preventing many undocumented immigrants from obtaining legal status. As part of one of those initiatives, the administration modified its consular guidance to address uncertainty for those who travel abroad for an interview and must request a waiver for previous immigration-related infractions. This update primarily benefits non-citizens who might qualify for employment-based temporary work visas. Why are border crossings at their lowest level in 4 years? Border crossings are at their lowest in 4 years. Is the Biden administration's executive action working as intended, or is there another factor at play? Apprehensions at the U.S.-Mexico border spiked to a record 250,000 in December 2023, but they've been falling since then. Beginning in January 2024, a crackdown by Mexico with the goal of wearing out migrants has made it harder for people to get to the U.S. border. As a result, border apprehensions have dropped every month of 2024 so far. This decline only accelerated in June when the Biden administration instituted a new rule which has led Border Patrol to turn away thousands of asylum seekers. This precipitous drop has sent border crossings to the lowest level in 4 years. It also reflects the fragile state of asylum seekers, caught in an increasingly tight bias between state pressure and rising desperation. Meanwhile, in New York, missed mail is complicating migrants' immigration cases. Exacerbated by shelter deadlines, migrants can receive mail at the city's shelters, but many face difficulties tracking down important correspondence, legal service providers and advocates report. This issue has intensified since the city imposed restrictions on the length of stays for both adults and families with children. Families with children are subject to 60-day limits in shelters, after which they must reapply for another placement. Adults and childless couples can stay for either 30 or 60 days, depending on their age, and must then meet specific criteria to qualify for extended time. City Hall did not clarify how long migrants' mail is retained after they move out, but migrants and legal service providers indicated it is typically held for 2 weeks post-transfer. Advocates suggest child care to reduce immigrant children selling candy on subways. Advocates are calling for improved child care options to address the issue of immigrant children selling candy on subways. A recent survey revealed that over 80% of vendors expressed a desire to pursue different employment, but were hindered by the lack of child care availability. The advocates argue that providing accessible child care could help families transition to more stable and secure jobs. In other news, USCIS revises criteria for immigrant entrepreneurs. The U.S. Citizenship and Immigration Services has revised the requirements for the International Entrepreneur Parole Program, imposing stricter investment and revenue benchmarks for immigrant entrepreneurs seeking to participate. Federal government argues against immigration organizations standing to sue over 2020 asylum rule. The federal government argued before a D.C. federal judge that 2 immigration advocacy groups lack standing to challenge a Trump-era rule that restricted asylum eligibility, asserting that the rule does not directly impact the organizations. Class action filed against ICE contractor over family separations. A father and son, separated for 6 years under the Trump administration's zero-tolerance policy on unlawful border crossings, have filed a proposed class action lawsuit against the private contractor responsible for transporting children. They seek compensation for the emotional trauma endured by affected families. Somalia temporary protected status extended and redesignated. The Department of Homeland Security, DHS announces that the Secretary of Homeland Security, Secretary, is extending the designation of Somalia for Temporary Protected Status, TPS, and redesignating Somalia for TPS for 18 months, beginning on September 18, 2024, and ending on March 17, 2026. This extension and redesignation allows Somali nationals and individuals having no nationality who last habitually resided in Somalia, who have been continuously residing in the United States since July 12, 2024, and who have been continuously physically present in the United States since September 18, 2024, to apply or re-register for TPS. And finally, do 287D agreements with ICE make communities safer? Texas SB 4 set the tone for the national discourse around immigration enforcement. Since then, certain states have felt emboldened to create their own immigration enforcement regimes, like Iowa and Oklahoma, which enacted equally strict copycat bills. Other states sought to strengthen the cooperation between local law enforcement agencies and immigration enforcement entities, such as U.S. Immigration and Customs Enforcement, ICE, through more established methods. Thank you.
Our weekly immigration news roundup is brought to you by the law firm of Figueroa and Associates. For a consultation on any immigration or legal matter, please call 855-768-8845. That's 855-768-8845. For full stories and more immigration news, visit www.theimmigrantsjournal.com. That's www.theimmigrantsjournal.com.
You are listening to Ask the Lawyer International Edition. You have questions? We've got the answers. Schedule an appointment now at www.askthelawyer.us. That's www.askthelawyer.us.
The following is a public service announcement from the law firm of Figueroa and Associates. To schedule a legal consultation on this or any other issue, please call 855-768-8845 or visit www.askthelawyer.us.
Romance scams, looking for love in the wrong places. The FBI warns of a rising trend in which scammers are defrauding victims via online romance scams, persuading individuals to send money to allegedly invest or trade cryptocurrency. Romance scams occur when a criminal adopts a fake online identity to gain a victim's affection and trust. The scammer then uses the illusion of a romantic or close relationship to manipulate and slash or steal from the victim. The criminals who carry out romance scams are experts at what they do and will seem genuine, caring, and believable. Con artists are present on most dating and social media sites. The scammer's intention is to establish a relationship as quickly as possible, endear himself to the victim, and gain trust. Scammers may propose marriage and make plans to meet in person, but that will never happen. Eventually, they will ask for money. Scam artists often say they are in the building and construction industry and are engaged in projects outside the U.S. that makes it easier to avoid meeting in person, and more plausible when they ask for money for a medical emergency or unexpected legal fee. If someone you meet online needs your bank account information to deposit money, they are most likely using your account to carry out other theft and fraud schemes. Tips to protect yourself. Never send money, trade, or invest per the advice of someone you have solely met online. Do not disclose your current financial status to unknown and untrusted individuals. Do not provide your banking information, social security number, copies of your identification or passport, or any other sensitive information to anyone online or to a site you do not know is legitimate. If an online investment or trading site is promoting unbelievable profits, it is most likely that unbelievable. Be cautious of individuals who claim to have exclusive investment opportunities and urge you to act fast. To report a scam to the FBI IC3, please visit www.ac3.gov. Did you marry a scammer? Time to get a divorce. Ask the lawyer. Schedule an appointment at www.askthelawyer.us.
You just listened to a public service announcement from the law firm of Figaro and Associates. To schedule a legal consultation on this or any other issue, please call 855-768-8845 or visit www.askthelawyer.us.
Love is in the air. Do you know that a prenup or an irrevocable trust can say, "I love you" in a way flowers and chocolates never could? Ask the lawyer. Let the law firm of Figaro and Associates show you how. Don't hesitate. Call 855-768-8845 or visit www.askthelawyer.us to schedule an appointment today.
Marriage fraud for green card purposes and federal immigration law protections when there are children in the marriage. Marriage fraud for green card purposes is a significant issue that challenges the integrity of the U.S. immigration system and can profoundly affect U.S. citizen spouses. This issue becomes even more complex when children are involved, as the presence of children can obscure the fraudulent nature of the marriage. This analysis explores how federal immigration laws are designed to protect U.S. citizen spouses from immigrants who may enter into marriages not for love but for immigration benefits, even when there are children from the marriage. Understanding marriage fraud. Marriage fraud defined. Marriage fraud occurs when an individual enters a marriage to obtain immigration benefits. This can include sham marriages, marriages contracted solely to secure a green card without intending to establish a life together. Deceptive marriages. One spouse deceives the other about their intentions, marrying primarily for immigration benefits while pretending to enter the marriage for genuine reasons. Federal immigration law measures. Federal immigration laws employ various strategies to prevent and address marriage fraud, even in cases involving children. 1. Conditional resident status. 2-year conditional green card. Immigrants who obtain a green card through marriage are initially granted conditional resident status for 2 years. This conditional status is designed to provide a probationary period during which the legitimacy of the marriage can be evaluated. Petition to remove conditions. To transition from conditional to permanent resident status, the couple must jointly file Form I-751, Petition to remove conditions on residence. This petition requires substantial evidence of a bona fide marriage, such as joint financial accounts, lease or mortgage documents with both names, birth certificates of children born to the couple, photographs and correspondence showing a genuine relationship. 2. Interviews and investigations. In-depth interviews. U.S. Citizenship and Immigration Services, USCIS, conducts interviews with both spouses to assess the legitimacy of the marriage. These interviews can be extensive, probing for inconsistencies in the couple's story and relationship. Site visits and investigations. USCIS officers may visit the couple's home unannounced or investigate further if they suspect fraud. This can include interviewing neighbors, colleagues, and family members. Protections for U.S. citizen spouses. Federal immigration laws offer several protections for U.S. citizens who may unknowingly marry someone committing marriage fraud. 1. Legal remedies and support. Annulment and divorce. If a U.S. citizen spouse discovers the marriage was fraudulent, they have the right to seek an annulment or divorce. Annulment, in particular, declares the marriage void from the beginning, which can have significant legal implications for the immigrant spouse's status. Protective orders. In cases where the immigrant spouse engages in coercive or abusive behavior, U.S. citizens can seek protective orders and other legal remedies to ensure their safety and well-being. 2. Awareness and education. Public awareness campaigns. USCIS and other federal agencies provide educational resources and public awareness campaigns to inform U.S. citizens about the risks and signs of marriage fraud. These resources help citizens recognize potential red flags and protect themselves from exploitation. Counseling services. Support services, including counseling and legal advice, are available for U.S. citizens in fraudulent marriages. These services can guide legal options and emotional support during difficult times. Impact of children on fraud detection. The presence of children in a marriage can complicate the detection of fraud, but federal immigration laws have provisions to address these complexities. 1. Increased scrutiny of evidence, detailed evidence requirements. When children are involved, USCIS requires even more detailed evidence to establish the bona fide nature of the marriage. This can include evidence of joint parenting responsibilities, school records showing both parents' involvement, medical records indicating joint decision-making for the child's health. 2. Interviews and family dynamics. Family interviews. USCIS may conduct interviews with not just the spouses but also older children, if applicable, to understand the family dynamics and verify the authenticity of the relationship. Behavioral indicators. USCIS officers are trained to look for behavioral indicators that suggest a genuine family unit, such as the nature of interactions between the parents and the children, and the involvement of both parents in the child's life. Consequences of marriage fraud. The consequences of marriage fraud are severe for both the immigrant and the U.S. citizen involved, even when children are present. 1. Immigrant consequences. Deportation and removal. Immigrants found guilty of marriage fraud face deportation and removal from the United States. They may also be barred from re-entering the country for a significant period or permanently. Criminal charges. Marriage fraud is a federal crime. Immigrants convicted of marriage fraud can face criminal charges, including fines and imprisonment. 2. U.S. citizen consequences. Legal repercussions. U.S. citizens knowingly participating in marriage fraud can also face legal consequences, including criminal charges, fines, and imprisonment. Emotional and financial impact. The emotional toll and financial impact on U.S. citizens can be significant, particularly if they were deceived and manipulated into a fraudulent marriage. They may face legal costs, emotional distress, and personal and professional reputation damage. Legal framework and enforcement. Several vital laws and regulations form the backbone of the U.S. approach to preventing and addressing marriage fraud. Immigration and Nationality Act, INA, Sections 216 and 216A. These sections of the INA outline the conditions for conditional permanent residence and the procedures for removing those conditions, emphasizing the need for a bona fide marriage. Marriage Fraud Amendments of 1986, strengthening penalties. The Marriage Fraud Amendments introduced stricter penalties for marriage fraud, including criminal sanctions and enhanced investigative measures. Immigration Marriage Fraud Amendments, IMFA, preventive measures. The IMFA introduced measures such as the 2-year conditional residency period and the requirement for joint petitions to remove conditions, focusing on deterring fraudulent marriages. Conclusion: marriage fraud for green card purposes poses a significant threat to the integrity of the U.S. immigration system and the well-being of U.S. citizen spouses, even when children are involved. Federal immigration laws are designed to detect, deter, and penalize such fraud through measures like conditional resident status, comprehensive evidence requirements, and thorough interviews and investigations. U.S. citizen spouses are protected through legal remedies, public awareness campaigns, and support services. The consequences for those involved in marriage fraud are severe, including deportation, criminal charges, and significant emotional and financial impact. By maintaining robust legal frameworks and enforcement mechanisms, the U.S. continues to safeguard the immigration process and protect its citizens from exploitation.
Hi, good day. My name is Ashaki Foster. I just want to send out a shout out to Mr. Figueroa and his staff, thanking them for all that they've done for me so far with my social, my green card, and now I'm finally a citizen. And I just want to recommend him to the people in the U.S. and also the Caribbean. Thank you.
Do you have a legal issue, question, or concern? Turn to Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us. You can also register for our paralegal program. Get legal news, business consults, or other information on educational issues. Yes, ask the lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us.
Breaking news. The Biden administration, in a humanitarian gesture, has decided to issue an executive order allowing individuals who have entered the United States illegally or without inspection to adjust their status within the country if they are the spouse of a U.S. citizen. This measure aims to prevent unwarranted delays and financial hardship. For more information on Biden's executive order, please contact the law firm of Figaro and Associates at 855-768-8845 or visit our website at askthelawyer.us to schedule a consultation. We praised President Biden for his efforts to keep families together.
Arle Lou Izon is a criminal, now deceased and indicted by the federal government for defrauding thousands of Grenadians. If you or a family member is a victim of Arle Lou Izon and are in deportation proceedings or any immigration matters pending in immigration court, please call the law firm of Figaro and Associates at 855-768-8845. That's 855-768-8845.
The following is a public service announcement from the law firm of Figaro and Associates. To schedule a legal consultation on this or any other issue, please call 855-768-8845 or visit www.askthelawyer.us.
Romance scams, looking for love in the wrong places. The FBI warns of a rising trend in which scammers are defrauding victims via online romance scams, persuading individuals to send money to allegedly invest or trade cryptocurrency. Romance scams occur when a criminal adopts a fake online identity to gain a victim's affection and trust. The scammer then uses the illusion of a romantic or close relationship to manipulate and slash or steal from the victim. The criminals who carry out romance scams are experts at what they do and will seem genuine, caring, and believable. Con artists are present on most dating and social media sites. The scammer's intention is to establish a relationship as quickly as possible, endear himself to the victim, and gain trust. Scammers may propose marriage and make plans to meet in person, but that will never happen. Eventually, they will ask for money. Scam artists often say they are in the building and construction industry and are engaged in projects outside the U.S. that makes it easier to avoid meeting in person, and more plausible when they ask for money for a medical emergency or unexpected legal fee. If someone you meet online needs your bank account information to deposit money, they are most likely using your account to carry out other theft and fraud schemes. Tips to protect yourself. Never send money, trade, or invest per the advice of someone you have solely met online. Do not disclose your current financial status to unknown and untrusted individuals. Do not provide your banking information, social security number, copies of your identification or passport, or any other sensitive information to anyone online or to a site you do not know is legitimate. If an online investment or trading site is promoting unbelievable profits, it is most likely that unbelievable. Be cautious of individuals who claim to have exclusive investment opportunities and urge you to act fast. To report a scam to the FBI IC3, please visit www.ac3.gov. Did you marry a scammer? Time to get a divorce. Ask the lawyer. Schedule an appointment at www.askthelawyer.us.
You just listened to a public service announcement from the law firm of Figaro and Associates. To schedule a legal consultation on this or any other issue, please call 855-768-8845 or visit www.askthelawyer.us.
Analysis of filing for U.S. citizenship with criminal arrests and convictions. The process of filing for U.S. citizenship, also known as naturalization, is governed by stringent laws and regulations. Navigating this process can be particularly complex for individuals with criminal arrests and convictions. This analysis will explore the various factors influencing eligibility for U.S. citizenship for those with a criminal record, including offenses, the concept of good moral character, the mandatory waiting period, and specific disqualifications. 1. Understanding criminal background and eligibility. The U.S. Citizenship and Immigration Services, USCIS, requires applicants for naturalization to demonstrate good moral character, GMC, for a specific period before applying. Criminal arrests and convictions can significantly impact this assessment. Here's how different types of offenses affect eligibility. Minor offenses. Traffic violations and minor misdemeanors generally do not bar applicants from demonstrating good moral character, provided they are isolated incidents. Serious crimes. Convictions for serious offenses such as aggravated felonies, drug trafficking, or violent crimes usually result in a permanent bar to naturalization. Moral turpitude crimes. Crimes involving moral turpitude, CIMT, such as fraud or theft, require careful examination. A single CIMT can disqualify an applicant, depending on when it occurred and the sentence imposed. 2. Good moral character, GMC, requirement. The concept of good moral character is pivotal in the naturalization process. USCIS evaluates GMC over the statutory period, typically 5 or 3 years for applicants married to U.S. citizens. Some offenses can permanently bar an individual from establishing GMC, while others impose a temporary bar during the statutory period. Permanent bars. Certain offenses result in a lifetime bar to establishing GMC, including aggravated felonies, murder, rape, sexual abuse of a minor. Any conviction for such crimes after November 29, 1990, results in automatic disqualification from citizenship. Temporary bars. Offenses like multiple DUI convictions, prostitution, or illegal gambling can create temporary barriers. Applicants must remain crime-free during the statutory period to qualify. 3. Mandatory waiting period. The waiting period is crucial for those with criminal convictions. Applicants must ensure that the statutory period has elapsed since the completion of their sentence, including probation or parole, before applying for naturalization. This period allows for the demonstration of reformed behavior and rehabilitation. Statutory period completion. Even if a crime does not result in a permanent bar, the applicant must wait until the statutory period has ended, typically 5 years. For some crimes, an additional period might be necessary to prove rehabilitation. 4. Effect of multiple convictions. Multiple arrests and convictions can complicate the naturalization process. USCIS examines the cumulative effect of these incidents on the applicant's moral character. Even if individual offenses might not disqualify an applicant, their combined impact could result in denial. Pattern of behavior. A pattern of repeated criminal behavior, even for minor offenses, may indicate a lack of good moral character. USCIS considers the frequency and nature of these incidents in their assessment. 5. Disclosure and documentation. Honesty and full disclosure of all criminal history are vital. USCIS requires applicants to provide detailed information about arrests, charges, and convictions. Failure to disclose this information can result in denial or revocation of citizenship. Document submission. Applicants must submit court dispositions, police reports, and other relevant documents. Providing comprehensive documentation helps USCIS assess the context and severity of the offenses. Honesty in application. Attempting to conceal a criminal record can lead to severe consequences, including application denial and potential deportation. Transparency is critical in establishing credibility. 6. Legal assistance and representation. Navigating the complexities of naturalization with a criminal record often necessitates legal assistance. Immigration attorneys can provide guidance on eligibility, help prepare the application, and represent applicants in hearings if necessary. Legal advice. Consulting an attorney before filing can help determine the likelihood of approval and address potential issues proactively. Representation. In cases where criminal history complicates the application, having legal representation can be crucial in presenting the best case to USCIS. 7. Special considerations. Certain circumstances may provide additional pathways or considerations for those with criminal records seeking citizenship. Juvenile offenses. Crimes committed as a minor may be treated differently, especially if the individual has demonstrated rehabilitation and good moral character since then. Pardons and expungements. While a pardon or expungement does not automatically remove the need to disclose a conviction, it can positively influence USCIS's decision. Applicants should provide documentation of any pardons or expungements and demonstrate their reformed character. 8. Appeals and waivers. If a naturalization application is denied due to criminal history, applicants may have options to appeal the decision or seek a waiver. Appealing denials. Applicants can file an appeal or request a hearing to contest the denial. Presenting additional evidence or clarifying misunderstandings during the appeal process could reverse the decision. Seeking waivers. In some cases, waivers for certain disqualifying offenses may be available. Legal counsel can advise on the feasibility and process for obtaining such waivers. Conclusion. Applying for U.S. citizenship with a criminal record involves navigating a complex legal landscape. The key factors influencing eligibility include the nature and timing of offenses, the demonstration of good moral character, adherence to the statutory period, honesty, comprehensive documentation, and legal assistance are crucial in improving the chances of a successful application. Understanding these elements can help individuals with criminal histories approach naturalization with greater clarity and preparedness.
Do you have a legal issue, question, or concern? Turn to Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us. You can also register for our paralegal program, get legal news, business consults, or other information on educational issues. Yes, Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us.
The United States is consistently ranked among the best internationally for its competitiveness. Are you planning to start a new business or branch of your business in New York? Attend our Chamber Coalition's 5-week webinar series, Small Business Sense Bootcamp. We provide education and business preparation for small business owners and startups. Learn the basics of business planning, how to finance your business, business credit, marketing, and social media strategies, small business solutions, legal, tax, accounting, banking, and insurance, and how to do business within New York City, New York State, and corporations. Register at startupsbootcamp.eventbrite.com.
Hi, good day. My name is Ashaki Foster. I just want to send out a shout out to Mr. Figueroa and his staff, thanking them for all that they've done for me so far with my social, my green card, and now I'm finally a citizen. And I just want to recommend him to the people in the U.S. and also the Caribbean. Thank you.
You are listening to Ask the Lawyer International Edition. You have questions? We've got the answers. Schedule an appointment now at www.askthelawyer.us. That's www.askthelawyer.us. askthelawyer.us.
Investigative analysis on the new deed theft legislation in New York State. Recently, New York Attorney General Letitia James announced enacting a new law establishing deed theft as a crime and expanding the Office of the Attorney General's OAG ability to prosecute these cases. Co-authored by Attorney General James and sponsored by State Senator Zellner Myrie and Assemblymember Landon C. Dace, this legislation marks a significant step forward in protecting homeowners from fraudulent property transfers. This analysis delves into the details of the new law, its implications, and the broader context of deed theft in New York. Understanding deed theft. Deed theft, or property title fraud, occurs when a fraudulent actor illegally transfers property ownership without the owner's knowledge or consent. This crime can have devastating effects on homeowners, particularly the elderly and those facing financial hardship, who may be targeted due to vulnerabilities. Common methods of deed theft. Forgery. Fraudsters forge the homeowner's signature on property transfer documents. False pretenses. Scammers deceive homeowners into signing documents under false pretenses. Identity theft. Criminals use stolen personal information to transfer property titles. Key provisions of the new legislation. Establishing deed theft as a crime. The legislation explicitly defines deed theft as a crime, providing clear legal grounds for prosecution. This definition encompasses various fraudulent activities related to property title transfers, making it easier to bring perpetrators to justice. Amending the statute of limitations. The new law extends the statute of limitations for deed theft cases, giving homeowners and prosecutors more time to uncover and address fraudulent transfers. This change acknowledges the often delayed discovery of such crimes, particularly among vulnerable populations. Granting original criminal jurisdiction to the OAG. One of the most significant aspects of the legislation is granting the OAG original criminal jurisdiction to prosecute deed theft. This provision enhances the OAG's ability to take swift and decisive action against offenders, bypassing the need to rely solely on local district attorneys. Implications of the new law. Enhanced legal framework. Establishing deed theft as a distinct crime creates a more robust legal framework for addressing property title fraud. This framework includes clear definitions, precise definitions of what constitutes deed theft. Stronger penalties. The law imposes severe penalties on those convicted of deed theft, serving as a deterrent to potential fraudsters. Improved prosecutorial power. With the OAG now holding original criminal jurisdiction, the office can initiate investigations and prosecutions more efficiently. This power includes direct prosecution. The OAG can directly prosecute deed theft cases without waiting for local district attorneys to act. Resource allocation. The OAG can allocate specialized resources and expertise to handle complex deed theft cases. Support for homeowners. The extended statute of limitations gives homeowners more time to recognize and address fraudulent property transfers. This support is particularly crucial for elderly homeowners. Older individuals are often targeted due to their perceived vulnerability. Financially distressed homeowners. Individuals facing financial difficulties who may be more susceptible to scams. Broader context of deed theft in New York. Prevalence and impact. Deed theft has been a growing problem in New York, particularly in areas with high property values and significant financial distress. The impact on homeowners can be severe, including loss of home. Victims may face eviction from their homes. Financial hardship. Legal battles to reclaim property can be costly and time-consuming. Emotional distress. The stress and uncertainty of losing one's home can have significant emotional consequences. Case studies. Several high-profile cases have highlighted the need for stronger protections against deed theft. These cases often involve targeting vulnerable populations. Fraudsters frequently target elderly homeowners and those facing foreclosure. Complex schemes. Many cases involve sophisticated schemes that are difficult to unravel without specialized legal expertise. Role of the Attorney General's Office. Investigation and prosecution. The OAG plays a critical role in investigating and prosecuting deed theft cases. This role includes investigative units. Specialized units within the OAG investigate real estate fraud. Collaboration with local authorities. The OAG builds strong cases with local law enforcement and district attorneys. Public awareness and education. In addition to prosecution, the OAG raises public awareness about deed theft. Efforts in this area include educational campaigns, initiatives to inform homeowners about the risks of deed theft and how to protect themselves. Community outreach, engaging with community organizations to reach vulnerable populations. Investigative agencies responsible for monitoring grants and deed theft. Federal level, Department of Housing and Urban Development, HUD, monitors federal housing and urban development grants. HUD's Office of Inspector General, OIG, investigates fraud, waste, and abuse in HUD programs. Federal Bureau of Investigation, FBI, investigates large-scale fraud cases involving property title fraud and deed theft. State level, New York State Attorney General's Office, OAG. With the new law, the OAG has expanded powers to investigate and prosecute deed theft. New York State Department of Financial Services, DFS, regulates financial services and products related to real estate transactions. Local level, district attorneys. Local district attorneys have jurisdiction over criminal cases, including deed theft, within their respective counties. Local law enforcement. Police departments investigate initial complaints of property fraud and gather evidence for prosecution. Process of requesting an investigation. Steps for homeowners. Document the issue. Homeowners should gather all relevant documents, including property records, correspondence, and any suspicious documents they may have signed. Report to local authorities. File a complaint with the local police department and the district attorney's office. Contact the OAG. Submit a formal complaint to the OAG, providing all gathered documentation and a detailed account of the suspected fraud. Follow up. Maintain communication with the investigating agencies and provide additional information. Involvement of legal professionals. Consult an attorney. Homeowners may seek legal advice to understand their rights and the legal processes involved. File civil actions. In addition to criminal complaints, homeowners can file civil lawsuits to reclaim property and seek damages. Criminal and civil implications of deed theft. Criminal charges. Fraud. Deed theft typically involves fraudulent activities such as forgery and identity theft, which are criminal offenses. Penalties. Convictions can result in severe penalties, including imprisonment, fines, and restitution to the victims. Civil actions. Reclaiming property. Victims can file civil lawsuits to void fraudulent transfers and reclaim property ownership. Damages. Homeowners may seek monetary damages for financial losses and emotional distress caused by the fraud. Conclusion. The new law establishing deed theft as a crime and expanding the New York Attorney General's ability to prosecute these cases is a significant advancement in protecting homeowners from fraudulent property transfers. By defining deed theft explicitly, extending the statute of limitations, and granting the OAG original criminal jurisdiction, the legislation provides a robust framework for addressing this serious issue. The enhanced legal framework and prosecutorial powers will enable the OAG to take swift and decisive action against offenders, providing much-needed support to vulnerable homeowners. Public awareness and education efforts will also play a crucial role in preventing deed theft and empowering homeowners to protect themselves. In cases where grant funds were involved, federal, state, and local agencies have mechanisms to monitor and investigate the proper use of these funds. Homeowners and concerned parties can request investigations by documenting the issue, filing complaints with relevant authorities, and seeking legal advice. Ultimately, this new law's successful implementation and enforcement will depend on the collaboration between the OAG, local law enforcement, community organizations, and the public. By working together, New York can effectively combat deed theft and protect homeowners from this insidious fraud.
Do you want to be a paralegal? Or are you planning to go to law school? Our Chamber Coalition's online paralegal program is the right program to get you started. Some of the areas of law include contracts, property law, tort liability, civil procedure, constitutional law, immigration, civil rights, estate planning, wills and trusts, and matrimonial, plus legal research and writing, legal marketing, and small business. We also use Cali, which is used in law schools, and you get extra certificates from Clio and LexisNexis. By graduating from this program, you can market yourself as a virtual paralegal for attorneys and law firms in New York State. There is a one-time fee of $550. Are you excited to learn more? Register for an orientation at www.freeparalegal.org. That's www.freeparalegal.org.
In a world where silence hides violence, there's a beacon of hope. Join the Love Life Now Foundation as we stand up against domestic violence in Jamaica. Let your voice be the catalyst for change. Speak out against all forms of domestic abuse within your homes. Domestic violence is not a part of Jamaican culture. Together, we can break the cycle and help victims find safety. Love Life Now Foundation provides hearts and hands to those affected by offering vital resources and get safe assistance. To support our mission to empower victims to become survivors, call 1-876-824-6470. Love Life Now Foundation Jamaica. Together, we can heal. Together, we can make a difference. Stand up against domestic violence today.
Love is in the air. Do you know that a prenup or an irrevocable trust can say, I love you in a way flowers and chocolates never could? Ask the lawyer. Let the law firm of Fig, Rowe and Associates show you how. Don't hesitate. Call 855-768-8845 or visit www.askthelawyer.us to schedule an appointment today.
Do you have a legal issue, question, or concern? Turn to Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us. You can also register for our paralegal program, get legal news, business consults, or other information on educational issues. Yes, ask the lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us.
This show is a production of IQ Inc. Marketing. If you would like to advertise your product or service on this show to the U.S. and Caribbean markets and through our multicultural publications in New York, please call 866-435-3286 or send an email to info@myiqinc.com.
Thank you for listening to Ask the Lawyer International Edition with attorney Brian Figueroa of the law firm Figueroa and Associates in New York. We hope you enjoyed the show, which featured immigration visitors visa, starting and doing business in New York, entertainment and business visas, religious visas, and much more. Whether you are outside the U.S. or have family in New York, the number to call, share, and keep is 855-768-8845. That's 855-768-8845. Please schedule a consultation with us at www.askthelawyer.us. That's www.askthelawyer.us. This is Ask the Lawyer, International Edition. You have questions? We've got the answers.